Many thanks for a very generous introduction. Honorable Chairman and the Board of Control and the members of the staff of the Office for National Unity and Reconciliation. At the first annual conference 2021 on national unity and reconciliation, I thanks all the organizers for having me today for this wonderful annual conference. I also take this opportunity to extend my sincere thanks to Professor Jiva, whom I know for many years now, and it's a wonderful occasion to discuss this particular subjects. Well, ladies and gentlemen, I also acknowledge the presence of Professor Braithwaite, who has just made a very commendable exploration of the issue of reconciliation. Friends, I am going to speak on the idea of forgiveness in the criminal justice system. My talk is structured and titled as Enabling Criminal Justice System for Forgiveness and Healing. This talk is about the forgiveness in criminal justice system from the viewpoint of restorative justice, as forgiveness is in the core of reconciliation and healing. Now, the core issue is why the criminal justice system seems to become less and less responsive to the whole idea of forgiveness. Because probably we are living in times where mercy and forgiveness give way to retribution. Forgiveness and blame both come as natural response to human beings when faced with loss or injury of any kind. I consider forgiveness as condition to reconciliation and restoration, because without being, without having the idea of forgiveness, you cannot probably create and structure a proper system of restorative justice. So I state that forgiveness is a process of moving from ill will to goodwill towards offender. And it is compatible with various forms of justice now. Forgiveness is often the basis of reconciliation, the restoration of right relationship. Both of these depend in some ways on the acknowledgement of truth. Forgiveness can also play a vital role in efforts to promote restorative justice, which seeks to address harm suffered by the victim, wider communities, and even the perpetrators. Now, this idea of forgiveness is drawn from the notion that criminal harm is primarily a violation of public norms and community sentiment, and not necessarily a harm against the individual. Probably this transformation of the basic understanding of crime needs to be changed in order to bring the idea of restorative justice, including forgiveness, into the zone of our consideration. But at the same time, there is a discourse going on that the forgiveness in criminal law requires that the victim is not coerced to forgive, and offenders are not pushed to tender apologies. Individuals feel pressured to relinquish their own anger. That has to be kept in mind when the system of forgiveness is considered. I also say that there is a threat to the whole idea of restorative justice, or for that matter, reconciliation, because sometimes the individuals may be ready to forgive, but institutions do not. I'm saying this because of the fact that there is a resurgence of retribution in society. That is one aspect. But there is a resurgence of retribution in the ideologies dominating in the delivery of justice through various criminal justice systems in the country. In other words, the criminal justice system is also growing punitive. And in such a situation, there is hardly any space left for those progressive ideas which we are talking today in the realm of reconciliation and restoration. Now, people resent the idea of forgiveness as we as a society covertly expect our criminal justice system to extract revenge upon the offenders. So there is a silent desire on the part of a large number of people in the society that let the offender be put to some kind of restoration. Such dominance of retribution doctrine in criminal justice system has actually impeded the infusion of new ideas. It has undermined the much needed shift in criminal justice jurisprudence towards restorative, reformative, and rehabilitative conception of justice. I also mentioned that forgiveness can and should exist within the criminal justice system. Many people would argue that their countries do prescribe death penalty and harsh punishment. Therefore, there is no room for forgiveness, reconciliation, and restoration. But I am making this conscious statement from the viewpoint of a practicality that forgiveness can still coexist in such kind of criminal justice system. Clearly, forgiveness in the context of this kind of system cannot mean simply letting offenders off the hook without being held accountable for their actions. Rather, forgiveness can be seen as part of healing process for the offender and for the victim. Robert and Wright provides a very helpful definition of forgiveness as the willingness to abandon one's right to resentment, negative judgment, and indifferent behavior toward one who unjustly injures us. That is a very significant understanding which we gain. If I place the idea of forgiveness within the context of criminal justice system, contemporary criminal justice system, then we find two very dominating ideologies. One is that the system in most cases is a lawyer-driven system where a state has a monopoly, where the roles of other stakeholders are minimized to a very crucial extent. I'm talking about the role of offenders, victims, and communities. These entities do not play a very significant role in determination of what it makes to justice. There is a little effort to understand, heal, or reform the offender then. So police and lawyers take control of the process from the moment of crime report, and they forbid or discourage offenders and victims to have any contact or discuss a case. This is a situation in adversarial kind of system, which encourages more of a clash rather than a harmonious reconciliation. Now, in that sense, let us understand the criminal justice gives a false sense of justice. Criminal justice gives a false sense of justice to people in a vast number of cases, because disposal of cases by the court is equated with the delivery of justice. I say with a lot of conviction and based on all my research, that disposal of a case does not necessarily mean justice delivered. So this disposal-linked concept of justice is misleading from the viewpoint of victim, accused, and community and other stakeholders. The need is therefore to reformulate the idea of justice. We need to change this narrative of official form of justice. We need to bring in more of a community sense of justice, incorporating the victim sense of justice and the offender sense of justice. The need is therefore to reformulate the idea of justice. Presently, if you see the key words in our criminal laws and criminal justice system, invariably we read arrest, bail, incarceration, punishment, death penalty. This is the parlance of criminal justice system, which essentially highlights the ideology that the system follows. I'm proposing that uh, we need to replace these words with the terminology like protection, participation, forgiveness, empowerment, because these are the positive markers. So the positive sense of criminal justice system would change if we tend to focus some of these things. The operation of criminal justice cannot be limited to being a tool of revenge. Probably this discourse is dominating the globe at the moment, where the progressive thinkers in the criminal justice arena are clearly saying criminal law should remain a last resort. But we are making it as a first resort. So on a very simple things, on misdemeanor kind of things, criminal law is invoked. And when criminal law is invoked, there are dire consequences to the liberty and freedoms of the people, because the criminal justice agencies have a tendency to avoid the due process entitlements that may be admissible to the victims and offenders. Therefore, there is a very little room for the process of restoration and reconciliation in this case. So I'm saying that the original and conventional conceptualization of criminal laws being a tool of revenge has to change if we want to institutionalize restorative justice within the criminal justice system. My argument is, in many cases, in many countries, restorative justice has been taken away from the criminal justice process and is being posed as something very distinct and separate. However, I am arguing there is a need to integrate restorative justice within the framework of the criminal justice system to be able to become an effective tool of restoration. I'm saying rather criminal justice system must achieve some positive goals, because if you ask people generally what is the function of criminal law, they would invariably say that criminal law is meant to punish the people, to the wrongdoers. That may be a very fringe kind of objective, but the promotion of empathy and harmony by way of humanizing the relationship between the offender, victim, and society is a very important function that criminal law can do. And I also say that we need to revisit and reformulate the role of criminal law in repairing the broken relationship in the society. Because at the moment, criminal law and criminal justice system, they are rather promoting a kind of conflict in the society by way of emphasizing a very tardy and lengthy process of litigation. So parties are encouraged to be in the litigation rather than into a kind of peaceful, solutions. That peacemaking criminology is missing probably. Therefore, the criminal justice system is fundamentally incapable of healing. In its conventional role, the system does not provide any idea or any framework of healing, and it is incapable of healing and does nothing to repair broken relationship. That is the first argument that I am making in favor of forgiveness. Therefore, forgiveness to be sought as one of the options. I'm not saying that is the only thing. It can be one of the options in a large number of cases where the people need not to be sent behind the bar. Now, the logic of adversarial combat that we essentially have in our criminal justice system, that actually creates a lot of barrier in the primary dialogue that the parties can have. And the victim and community members play a very little role apart perhaps from allocating or submitting letters or sentencing, there is a little room for parties most involved to communicate. Forgiveness doesn't fit into most of the traditional justifications for punishment. Because I also say that we have wrongly reached to this conclusion that effectiveness of a criminal justice system is gauged on the basis of its ability to punish the people. But this is the larger narrative, and the effectiveness of criminal justice system in most cases is judged by its capability to arrest the people and its capability to send people behind the bar, rather than the cases which are restored and reconciled. And I also say that uh, forgiveness by victims seems to have little or no bearing on an offender's dangerousness and need for incapacitation for a specific deterrence. And therefore, there is every case. Now, let us understand the forgiveness and mercy. Because a criminal or any other offender inflicts both tangible and intangible harms upon the victim. Therefore, there is a need to restore both kind of harms. The insult and degradation are moral injuries, creating a moral debt that wrongdoer owes to the victim. This disrespect of victims' worth justifies the victim's resentment of the offenders. I am not sort of advocating that the victim should never be resentful to the harm that he or she has suffered. But I am saying there is a need to translate this resentment into some viable system which can make the offender to express his or her remorse and regret and acknowledge the harm that he or she has done to the victims of crime. Until that happens, we would probably promoting a kind of conflict-ridden criminal justice system, which would not be proper in the long run for maintaining peace and calm in the society. I also say that forgiveness basically involves overcoming one's resentment of an offender for having inflicted an injury. We also understand the victim essentially harbors resentment for the wrong done to himself, but forgiveness involves an internal emotional change, but it also expresses itself in an action. So for forgiveness to be meaningful, the victim must also manifest it by canceling or remitting the moral debt and repairing his breached relationship with the offender. So therefore, forgiveness requires surrendering one's personal resent, that is, not taking the offense personally, because criminal law is a public law, and we have taken this entire idea to that level. Now, what are the benefits of promoting forgiveness in the criminal procedure and the criminal system? Because a more personalized, concrete criminal justice system could give much, weight or a greater weight to the interest and desire of the offender, victims, and community. And these things are very important. And from the viewpoint of offenders, forgiveness may counteract negative publicity and infamousness associated with a crime, making it easier for the offenders to reintegrate into society. And criminal justice system could do much more to encourage defenders to pave the way for forgiveness by admitting guilt, expressing remorse, and apologizing. From the viewpoint of victim, having been victimized, many victims are understandably angry, scared, sorrowful, or even grief-stricken. So we naturally assume that victims therefore want vengeance and call for blood. But empirical evidence suggests that victims are far less vengeful than one might think. That is a very important hope for us to emphasize the idea of forgiveness in the criminal justice system. Now, there can be various arguments. How should a victim's forgiveness or refusal to forgive affect the punishment? Now, today, probably the law in many countries are being refined and improved to provide a legal basis for mercy. So, expression of forgiveness may remit the victim's claim for punishment, and the state should heed the claim of the most interested party, because in many cases, the victim's claims do not form a part of any legal process. So I'm saying unless all that change, probably we would not be very effectively able to discharge this particular important responsibility. Forgiveness helps the victim in a variety of ways. However, as a matter of conclusion, I can say that the power to forgive and dispense mercy places the victim above the offender. So there is a moral win for the victim, at least partly rectifying the power imbalances and empowering the disempowered victim. I have read a year ago a very foundational book uh, by Martha Minow, a former dean of Harvard Law School in the US. That book is titled When Should Law Forgive? When should law forgive essentially, advocates a thesis exploring a number of possibilities where law can be very, very forgiving. To give you just a very simple example, in any system, as many as 30 to 40% crimes are of very simple kind and simple nature. In most countries, on account of those crimes, the offenders are sentenced to prison for a small duration of punishment ranging from 6 months to 2 years or 3 years, maybe. Now, these 30 to 40% crime can be taken to some alternative routes where the victim and the offender can be the party in order to bring some kind of restoration, reconciliation. But as I have been repeatedly saying, forgiveness becomes a very essential condition in all those pursuits. So the empirical evidence of restorative justice outcomes certainly suggests that participating offenders are more likely to apologize, and sympathetic enough to forgive were already less likely to recidivate. Nevertheless, apology and forgiveness may reduce recidivism by fostering offenders' resolution to change their lives and opening doors to lawful employment. To conclude, I would again say that forgiveness can be a key reform in the criminal justice system that will discourage incarceration epidemic and over-criminalization in many countries. It is estimated, as I am saying, that 40% of incarceration and litigation in any system is avoidable and therefore conditionally pardonable. Such institutional mercy can free up resources of the state besides subduing the perpetuation of conflicts that result from the adversarial legal process. This manner of operation of criminal justice afflicts millions of people. The avoidable 40% includes accused of petty offenders, small disputes relating to family, property, and disputes of other kind. These can be resolved through restorative process, a strategy where conferencing circles are organized to make the wrongdoers accept the harm done and to explore means to restore harm caused. So with this, I close. Thank you so much for a very patient hearing. Thank you, one and all.